Your 12-year-old daughter just hit 100,000 YouTube subscribers. She's making $3,000 a month from ad revenue, sponsorships, and affiliate links. You're proud of her. You're helping her film videos, edit content, manage her social media. You're putting that money toward her college fund, family expenses, maybe a nicer camera setup. Seems responsible, right? Wrong. In 8 states, you just became legally liable for wage theft. And when your daughter turns 18, she can sue you for every penny she earned, plus interest, plus damages, and she will win. Before we dive in, do me one favor. Hit that subscribe button right now. Why? Because 90% of parents with child influencers have no idea these laws just changed, and I don't want you to be one of them. What I'm sharing today could save you from a 6-figure lawsuit from your own child, so click that button and let's get into it. Here's what just happened. In 2026, 8 states passed what's being called the Child Influencer Protection Act. These states are California, Illinois, New York, Washington, Minnesota, Maryland, Massachusetts, and New Jersey. And the lawsuits are already starting. This law treats child social media influencers the same way child actors have been treated since the 1930s. Remember the Coogan Law? That's the law that came about after Jackie Coogan, a massive child star in the 1920s, discovered when he turned 21 that his parents had spent all of his earnings. He sued, and California passed a law requiring that 15% of a child actor's earnings be placed in a blocked trust account that only the child can access when they turn 18. That was almost 100 years ago for Hollywood. In 2026, it finally applies to social media. But here's the problem. Most parents running their kids' YouTube channels, TikTok accounts, or Instagram pages have no idea this law exists. They think of it as a family project, not child labor. They're using the money for household expenses, reinvesting it in content creation, or saving it in their own accounts. All of that is now illegal in these 8 states. Let me break down exactly what the law requires. First, if your child appears in monetized content more than 30% of the time, or if their name, image, or likeness is the primary draw of the content, that child is legally considered a child influencer. Second, you must set up a Coogan account or similar blocked trust account within 30 days of the child earning their first dollar. Third, you must deposit at least 15% of the gross earnings attributable to that child into the trust account within 30 days of receiving payment. Notice I said gross earnings, not net. You don't get to deduct your expenses first. If a brand pays $10,000 for a sponsored video featuring your child, $1,500 goes into the trust account before you touch anything else. Fourth, you must keep detailed records of all earnings and all deposits. The law requires annual reporting, and if you're audited and can't produce records, you're presumed to have violated the law. Fifth, the trust account must remain blocked until the child turns 18. You cannot access it, borrow from it, or use it as collateral for loans. It's legally the child's money. Now here's where it gets really serious. If you violate this law, your child can sue you when they turn 18. They have until age 21 to file the lawsuit, so they've got a 3-year window. And courts are taking these cases very seriously. Let me tell you about the first major case that just settled in California. A 17-year-old girl who'd been a family vlogging star since she was 8 discovered that her parents had made over $2 million from content featuring her over 9 years. They'd spent almost all of it on their lifestyle, including a house, cars, and vacations. When she turned 18 in early 2026, she sued under the new law. Her parents argued that it was a family business, and she benefited from the nice house and lifestyle. The court didn't care. The judge ruled that the child was entitled to 15% of all earnings from content where she appeared, which came to over $300,000 plus interest, which added another $45,000 plus her attorney's fees, which were $80,000. Total judgment, $425,000. The parents had to sell their house to pay it. Quick question before we continue. Are you subscribed yet? No? Then you're missing out on legal updates that could protect your family from financial disaster. Hit that button now, because what I'm about to reveal next is the part that's catching the most parents completely off guard, the retroactive nature of this law. Here's what shocks people. Even though the law went into effect in January 2026, courts are allowing children to sue for earnings going back several years. Why? Because the statute of limitations for contract and wage claims in most states is 3 to 6 years. So if your child has been a social media influencer since 2022, they can potentially claim 15% of everything they earned from 2022 forward. Let's do some math. Say your family YouTube channel has been making $50,000 a year, and your 2 kids appear in 80% of the videos. That means roughly $40,000 per year is attributable to the kids. 15% of that is $6,000 per year. Over 4 years, that's $24,000 per child. If you haven't been putting that money in a trust account, you now owe both kids $24,000 each, plus interest. That's nearly $50,000 you have to come up with when they turn 18, or they can sue you. And here's the part that really keeps family vlogger parents up at night. The law doesn't just cover earnings you received, it covers earnings you should have received but didn't properly negotiate for. Let me explain. If a brand approached you for a sponsored video and you agreed to do it for $1,000, but a reasonable rate would have been $5,000, your child can argue you failed to properly monetize their labor and sue you for the difference. This is called the Fiduciary Duty standard. As a parent managing your child's earnings, you have a legal duty to act in their best financial interest. If you take lowball deals because you don't know the market, or if you do free sponsored content in exchange for products instead of cash, you've potentially violated your fiduciary duty. I've already seen 2 cases where young adults sued their parents, not just for the 15% they should have saved, but also for failing to maximize earnings potential. The courts are treating parents like they're managers or agents and holding them to professional standards. Now let's talk about sharenting. That's the term for parents sharing photos and content about their children on social media. Even if you're not making money from it, there's a new legal risk you need to understand. Several states are now recognizing what's called a future right of publicity claim. Basically, your child can argue that you exploited their image without consent and damaged their future ability to control their own public persona. Here's a real example. A mother in Illinois ran a mommy blog and Instagram account with 500,000 followers. She posted daily photos and stories about her daughter from birth through age 10. The content wasn't monetized directly, but the mother got free products, invited to events, and eventually a book deal worth $200,000. When the daughter turned 14, she became aware of how much of her childhood was documented online. She was mortified. Other kids at school had access to photos of her potty training having tantrums in the bathtub as a toddler. She's now 16 and has told her mother she plans to sue when she turns 18. Her claim is that her mother violated her privacy rights and her right of publicity by using her image to build a personal brand without her consent. Legal experts think she has a strong case, especially for the book deal earnings. The law is recognizing something important here. Children cannot consent to being turned into content. They're too young to understand the implications. And just because you're the parent doesn't mean you have unlimited rights to exploit your child's image for profit or personal gain. This is a fundamental shift in how courts view parental rights versus children's rights in the digital age. If you're finding this helpful, imagine what you'll learn in my next video about the 5 social media posts that can get your kids taken away by CPS. This is real and it's happening. Hit subscribe right now so you don't miss it. Now, let's talk about what you should do if you're a parent with a child influencer. Step 1, immediately determine if you're subject to the law. Are you in one of the 8 states? Does your child appear in monetized content? Calculate what percentage of your content features your child. If it's over 30%, you're covered by the law. Step 2, set up a Coogan account or blocked trust account. You can do this through certain banks and financial institutions that specialize in these accounts. It usually takes about a week and costs around $200 in setup fees. Step 3, calculate how much you should have already deposited. Go back through your earnings records. Determine what portion is attributable to your child. Calculate 15% of that. That's what you owe. Step 4, make a lump sum deposit to catch up, or set up a payment plan if you can't afford the lump sum. The law allows you to cure past violations if you do it proactively before your child sues, but you need to document everything. Step 5, going forward, deposit 15% of gross earnings attributable to your child within 30 days of receiving payment. Set up automatic transfers if possible. Step 6, keep meticulous records. Every payment you receive, every deposit you make, every expense you claim. You need a paper trail that would survive an audit. Here's something else you need to know. The law applies to each child individually. If you have 3 kids who appear in your content, you need 3 separate trust accounts with 15% going to each child. If all 3 appear equally, that's 45% of your earnings going into trust accounts. This has forced a lot of family vloggers to completely reconsider their business model. Some have stopped featuring their kids at all. Others have cut back to only featuring the kids occasionally, so they stay under the 30% threshold, and some have just accepted that nearly half their revenue has to go to the kids and they're budgeting accordingly. Let me tell you about one family that handled this really well. They run a family travel channel with 800,000 subscribers. When the law passed, they sat down with a lawyer and an accountant. They restructured everything. They created separate LLCs for different revenue streams. They set up Coogan accounts for their 2 kids. They negotiated with brands to pay the kids directly for sponsored content. They now operate like a small production company with the kids as contract talent. It's more complicated, but they're fully compliant and they've actually increased their earnings because brands respect the professional setup. Now, I know some of you are thinking, this is ridiculous. It's my kid. I'm feeding them, clothing them, paying for their education. Why should I have to set aside 15% of earnings for them? I get the frustration, but here's the legal reasoning. Your child is working. They're performing labor that generates income. The fact that they're your child doesn't mean you can keep all the money. You have a legal obligation to support your child anyway through age 18. whether they're earning money or not. The money they earn through their work is their money. The law allows you to keep 85% to cover expenses, management, reinvestment, and taxes, but 15% belongs to them. And honestly, given that child actors have had this protection for 90 years, it's not radical to extend it to child social media stars. If anything, it's overdue. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 parents who get these legal updates first. Click subscribe because child protection laws are evolving fast and you need to stay ahead of them. All right, let's talk about enforcement. How are states actually enforcing this law? Right now, it's mostly complaint driven. When a child turns 18 and realizes their parents didn't comply, they hire a lawyer and sue. The state isn't proactively auditing family vloggers, but that's changing. California's Labor Board has announced they're launching an investigation unit specifically for child influencer cases. They're going to start requiring parents to register child influencers, similar to how child actors need work permits. If you don't register and your child is clearly working as an influencer, you can be fined up to $10,000 and potentially face criminal child labor charges. Other states are watching California's approach and will likely follow. Within the next 2 years, I expect we'll see a registration and permitting system in most of the 8 states with these laws. There's also talk of requiring financial audits. Some proposed bills would require parents with child influencers earning over $50,000 per year to submit annual financial reports showing they're complying with the trust account requirements. If they can't prove compliance, their child's work permit gets revoked, and they can't legally create monetized content featuring the child. Now let's address the elephant in the room. What about all the family vloggers who've been doing this for years and have spent all the money? What happens to them? Some will get sued and lose everything. I'm predicting we'll see at least 50 major lawsuits in the next 3 years as the first wave of child influencers turns 18 under these new laws. Some parents will try to settle with their kids before it gets to court. Others will file for bankruptcy, though that might not discharge the debt since it's based on a fiduciary duty violation. And some will just hope their kids don't sue. Maybe the relationship is good enough that the kid doesn't want to destroy their parents financially, but that's a risky bet. Don't gamble with your financial future and your relationship with your child. Do the right thing legally and ethically. Set up the trust account, make the deposits, keep the records, and maybe, just maybe, have a conversation with your child about whether they actually want to be a public figure. Because here's the thing nobody talks about. A lot of these kids didn't choose this life. Their parents chose it for them when they were too young to consent. And now they're growing up with their entire childhood documented and monetized online. Some of them are okay with it. Some of them resent it deeply. And those are the ones who are going to sue the day they turn 18. Share this video with every parent you know who posts content featuring their kids. This is information that could save families from devastating legal and financial consequences. Drop a comment below and tell me, do you think these laws are fair? Should parents have to set aside earnings for their child influencers? I want to hear your perspective because this is a controversial topic and there are legitimate arguments on both sides. Remember, being a parent is hard enough without accidentally violating child labor laws. Stay informed, protect your kids, protect yourself, and I'll see you in the next video.